Good afternoon and welcome to this SRA webinar to launch our Risk Outlook 2015. I'm George Hawkins, a Senior Technical Advisor at the SRA, and I'm joined today by Laura Holloway, an SRA Risk Analyst.
Good afternoon.
Both of us were involved in researching and writing this year's Risk Outlook, and we'll be presenting a short summary of the document, followed by a question and answer session. The presentation will last about 20 minutes, with the remaining time dedicated to answering your questions. So if you would like to submit a question, please click on the Ask a Question button and type your question. You can also use the Ask a Question button to report if you are having any technical problems with the webinar. Below the Ask a Question button, there are two further buttons, Overview and Resources. These enable you to download a PDF version of the presentation. And we hope you enjoy today's webinar. So today, we will begin with Laura explaining a little bit about what the Risk Outlook is and what is driving change in the legal market. Then we'll go on to talk about our 8 priority risks and the steps we're taking to manage them before answering your questions.
Thank you, George. So what is the Risk Outlook? Well, some of you may already have seen this year's Risk Outlook report on our website. For those of you that haven't, here's a sneak peek at some of the content on your screen. This is the third year we've published the Risk Outlook, which is our annual summary of the risks that matter to us. For each risk, the report includes a description of the risk, why it matters, some up-to-date trends, and information about our controls. There's also a bit of information to help you manage the risks within your own firm. We hope to strike the sometimes difficult balance between, on one hand, freeing up firms to do business, to grow, and to innovate, and on the other hand, maintaining the quality and public protection that is fundamental to the legal sector. One of the questions that we often get asked is, what are the risks to? And this really explains that. Our role as a regulator is to protect the public and to support the rule of law and the proper administration of justice. Effective identification and management of risk can help us fulfil this purpose. The Risk Outlook should help you understand why we care about certain risks and help you to manage them in your own businesses. Managing risk doesn't need to be expensive, and it can be as much about making the most of opportunities as it can be about preventing problems. Essentially, managing risk is good for your business and your clients, as well as your regulator. So please do go to our website and have a look at the Risk Outlook document. This year there's also extra online content, which includes case studies and also a short description of each risk, so you can use the content in a way that best suits you. We're now going to move on to talking about the drivers of change in the legal market, which is the first section of the Risk Outlook report. Analysing drivers of change helps us to understand what might lead to new risks or lead to some risks being reduced. The good thing about this section of the Risk Outlook is that it provides some wider context for thinking about how changes could affect your business. Understanding the bigger picture can make it clearer how your firm can take advantage of market developments. So our first driver of change is the needs and behaviour of those people who use legal services. Individual law firms should understand the preferences of their clients, but still look at the wider picture, which can help identify opportunities. News here is positive. We are seeing firms delivering services in new ways, which shows that they are responding to consumer preferences. For example, the chart on the slide shows that many types of service are now being provided for a fixed fee. Clients now have more choices about how they are billed and have the choice of options including unbundled services and online provision. However, there is still considerable evidence that accessing appropriate legal services is something many people still find difficult. Barriers to access are often related to affordability or to not knowing where to go for support. As you can see from the slide, a significant minority of people still feel that legal services don't represent good value for money.
Thank you, Laura. So as well as those people who use legal services, change in the market is also driven by the solicitors and firms who provide these services. We can now see a much wider range of organisations delivering legal services, particularly since the introduction of alternative business structures in 2012. The range of different types of legal business is likely to continue to increase in the future as individuals and firms take advantage of the opportunities offered by things like evolving technology and regulatory reform. A wider range of providers is likely to lead to greater choice for consumers. This is all good news, but it does mean that existing firms will face increased competition. Competition can drive increased choice, efficiency and quality. Firms are able to manage the risks that result from commercial pressures. Senior solicitors must consider whether they have a viable exit or succession strategy in place for their business and think about the potential impact on clients if they had to close without any plans in place.
Thank you, George. Our next driver is regulation and legislation. Our regulation has an impact on the way that the market develops, as does government legislation. Legal requirements such as complying with anti-money laundering legislation or protecting personal data sit alongside SRA regulations as part of solicitors' compliance requirements. The Risk Outlook presents a timeline of our regulatory reform over the last year, which includes reducing administrative burdens, for example, the ending of the annual keeping of the roll exercise, and improving our support for small firms with the introduction of a specialist support team. We've also highlighted recent consultations, such as our proposals for third-party managed accounts and reforms to the professional indemnity minimum terms. I've personally found this timeline really helpful as it organises all the different changes that have happened and gives you a sort of bird's-eye view of the things that we've been doing.
So finally, the final economic driver is, of course, the economy. Now, the national economic recovery has seen turnover increase in the legal sector, alongside increased legal job opportunities and an increase of nearly 3,000 more practicing solicitors last year. However, of course, we are aware that there are actually many subsections of the legal market, and each solicitor will therefore be managing a slightly different set of risks in a different economic context. So that's a quick summary of our drivers this year. I'm now going to outline our 8 priority risks for 2015. If you have any questions about the drivers or any of the risks that we're going to go on to discuss, please use the Ask a Question button. So you can see from the screen what our 8 priority risks are. Briefly, we discuss standards of service, misuse of client money, a lack of a diverse and representative profession, lack of independence, improper or abusive litigation, information security issues, bogus law firms, and money laundering. Although these risks are independent of each other, there are some key themes running through all of them: quality, professional standards, and appropriate systems and controls. You may want to think about which risks are particularly relevant to your firm. Okay, so our first risk is the failure to provide a proper standard of service or quality, particularly for vulnerable clients. As you can see, the key message from this section is that clients are not always able to judge good service or quality, and some situations make people more vulnerable. Our regulation must ensure that certain standards of quality are met, as outlined in our competence statement that was published earlier this year. Quality of service is particularly important when vulnerable clients are involved. A vulnerable person could be someone with a limited ability to judge the quality of legal advice, someone in a stressful situation, or perhaps someone who's experienced a trauma or a personal tragedy. Service issues that come to light through complaints to ourselves and the legal ombudsman are likely to be the tip of an iceberg. Research has found that many dissatisfied legal services clients do nothing. Evidence also suggests that vulnerable people are less likely to complain to the solicitor or firm, less likely to complain to the legal ombudsman or the Solicitors Regulation Authority, and not always able to judge the quality of service until it's too late. Therefore, our regulation must provide adequate protections for those who need it most without restricting choice or leading to additional costs, and this is one of the greatest challenges we face. To support you with this, we have a number of case studies on our website outlining how standard of service issues can play out. Thanks, Laura. So our second risk is the misuse of client money. This issue presents a consistently high level of risk and causes severe harm to consumers when it takes place. We now receive around 100 reports of misuse per month. This is reduced from over 150 reports a couple of years ago, in line with the economic recovery. We have seen a number of recent cases connected with firms failing to detect rogue individuals or not having systems and controls in place to prevent misuse. It is worth considering the controls you have over who can access the client's account and whether staff are adequately supervised. Our regulatory reforms agenda is looking at ways of incentivising firms to hold less client money, but this is only one way that this risk can be reduced.
Thank you, George. So I now move on to the lack of a diverse and representative profession. Several national publications, including reports by the Social Mobility and Child Poverty Commission, have highlighted the lack of diversity in the legal profession when compared with other sectors and when compared with the population in general. Everyone working in the legal sector obviously wants to hire the best person for the job. However, we all need to be aware of the unconscious biases and barriers which could affect people's ability to get jobs and to progress through the ranks. There are several indicators that highlight that there may be problems with equality of access and progression in the legal profession. For example, 40% of partners at the largest law firms are privately educated, whereas for the general population that figure is only around 7%. Women also make up over half of newly qualified solicitors, but only 30% of partners are women. It's important that the legal workforce is broadly representative of the population it serves. This is vital for reasons of proper administration of justice and access to legal services. There's also a substantial business case for diversity, as it prevents groupthink and makes your business attractive to clients and new recruits alike. There's some good resources on our website around diversity. It can be difficult to think about examples, so we've produced some more case studies for you this year. There's also our diversity toolkit, which allows you to look at trends in your area.
Thank you, Laura. So we're now going to talk about lack of independence, and following this we're going to talk about improper or abusive litigation. There are similarities between those two risks that I can touch on a little later. We're beginning to focus on how solicitors maintain their professional standards. So the risk of a lack of independence applies to people working in all law firms of all sizes. We know that solicitors are frequently put into situations where their professional duties are placed into conflict, and they need to have the ability and awareness to navigate it appropriately. Whilst operating in an environment with commercial pressures, many firms feel that power is shifting towards the client. However, this commercial pressure does not mean that their core professional responsibilities are changing. Independence should not be overridden by the promotion of a client's interests, acceptance of a client's terms, a desire to maximise commercial return. It is important that legal services are free for undue influence. This could include situations when a solicitor responds to pressure on their interpretation of law or what actions are appropriate in a given situation. Issues concerning the use of their client's account, for example, using this to offer a personal banking facility, or to knowingly mislead the court or conduct litigation that does not have legal merit. This risk isn't easily identified and reported to us. It is therefore important that solicitors understand what is expected of them with regard to independence. It is one of the cornerstones of professional integrity and something that has solicitors held in high regard across the world. You'll be hearing much more about professional standards in the coming weeks. And that leads us quite neatly on to improper or abusive litigation. We wrote a topic paper in March called Walking the Line, Balancing Duties in Litigation, and the online resources that the Risk Outlook 2015 provides include links to that paper. So improper or abusive litigation is the misuse of legal proceedings to gain an unfair advantage or benefit for a client, or in some cases the solicitor. Examples of this type of behaviour include predatory litigation against third parties, abuse of the litigation process, such as incurring unmanageable costs, exploiting a third party's lack of knowledge of the legal process, misleading the court or giving false information, and excessive litigation. In some cases, these practices will represent a failure to act with integrity or ethics. However, each case will depend on its own facts. So to reiterate, our paper, Walking the Line, explores these issues in more detail, and there have been a number of recent statements by judges on inappropriate behaviour in litigation, wasting the time and money of the court system. Again, our online Risk Outlook resource includes updated case studies on this risk and more information about the trends we are seeing in the market.
Thank you. So now I'm going to cover information security and cybercrime, which has been front page news in many legal publications. This risk is also a key priority for law enforcement agencies around the world. How to keep information secure is a key challenge of modern business. We see cybersecurity at law firms as a priority, and our focus is on protecting client money and information. It is important that firms have appropriate systems and controls to manage this risk. However, it is worth remembering that before the age of IT, some law firms also failed to protect client information and money as a result of poor paper-based systems. So that's things like leaving files on trains or locked in cars. It's also worth being aware that the majority of cyber attacks can be prevented through relatively simple, low-cost actions. Controls such as educating employees to avoid guessable passwords, not opening attachments in unsolicited emails, and not using personal email to send and receive work-related documents can all help ensure that you don't become a victim of cybercrime. Protecting client information is a regulatory requirement, but it is also something that is vital to the commercial interests of your firm. We published a paper on cybercrime 2 years ago highlighting the risks, but already different types of threat have emerged. The pace of change is very fast, and you can find details of new scams and some new case studies on our website.
Now on to bogus law firms. This risk is closely linked to cybercrime, as the internet and advancing technology has made it easier for someone to impersonate a solicitor or firm just by copying a letterhead or setting up a website or email address. Criminals are increasingly using solicitor and firm identities to attempt to steal money and information. We are seeing more sophisticated threats emerge. Examples include using a solicitor identity in a phishing email to try and get bank details or personal information, and intercepting real transactions and pretending bank account details have changed in order to obtain client funds. These are a couple of examples of the case studies that are featured on our online content. But it's a key point that you need to understand, which is that firms are not powerless when it comes to preventing bogus law firms. Checking that the solicitors on the other side of a transaction are genuine providers provides a key protection for your clients. And regularly searching the web for your firm name can help you identify if someone is impersonating you. Scam awareness is essential, as bogus firms and frauds are changing all the time. We provide scam alerts on our website and have some case studies online about recent bogus firm scams.
Thanks, George. So for our final risk, we have money laundering, specifically the inadequate systems and controls over the transfer of money. The legal sector is a target for criminals wishing to launder money, as legal involvement can provide legitimacy to transactions. It's vital that firms are aware of this and have systems and controls to prevent their firm being misused by criminals. We have been visiting law firms over the last year to discuss their systems and controls around money laundering. Our findings were mixed. There was a lot of good practice, but there were also firms who needed advice on how to be improved. We will be publishing the findings in a report out later this year. However, a key point we want to get across, particularly for smaller firms, is that a local client base built on recommendations will not prevent a criminal from attempting to use your firm to launder money. Anti-money laundering knowledge is also a key competence for solicitors looking to start a law firm, particularly doing work like conveyancing, which presents a higher risk of money laundering. This is because in smaller firms, a senior partner will usually become the firm's money laundering reporting officer and needs to have the knowledge to carry out this role. To have anti-money laundering controls is a legal obligation, and your obligations are outlined in the risk outlook, not just a regulatory requirement. We will continue to focus on money laundering controls as a priority, particularly given that in the next couple of years, the UK will receive an inspection visit from the international body that oversees money laundering, and the legal sector is likely to be under the microscope. So those were our 8 priority risks. Now just a little bit about the resources available. The full report was published on our website on the 21st of July, which was 2 days ago. We also have new interactive web content, as we've previously mentioned. This is some short and snappy summaries of each risk, plus 29 new case studies which cut across all the risks. You may find that this is useful in training. We also will provide you some ideas about the type of controls you could use. So if you want to look at our web content, it's www.sra.org.uk/risk. We would now like to take some time to answer your questions. If you would like to participate in this question and answer session, please submit your question using the text box on your screen. We're just going to give you a few minutes to do that, and then we'll start answering your questions. Okay, so I'm going to offer the first question up to George to answer. And the question is, could you tell us a little bit more about the Walking the Line paper about conflicting duties in litigation, how that came about and how we can use it?
Thank you, Laura. Yes, of course. So it was launched as part of our spring update, and it's worth noting that the risk outlook is obviously our annual view of the priority risks, but we do update it in the autumn, in the spring. It's normally around November and March, and it's often accompanied by topic papers that we've had some very good feedback on, and particularly this one, it seemed to chime with solicitors who are beginning to engage with us about these kind of issues around professional standards and how to manage conflicts of duties. So I'll tell you a little bit more about why this risk is important, and a little bit more about the paper as well. The paper was originally based on a number of case studies, and we drew from information passed to us from the courts, from clients and from other sources, and we began to think that it was worth putting a paper together that recognised some of the issues that litigators face. And I think it ultimately centres on the requirement to have an understanding of key duties. Of course, solicitors have a duty to their client, but they're not hired guns. They also owe duties to the court. In some cases, they owe duties to third parties. And of course, there's the wider duty to serve the public interest and to promote the proper administration of justice and uphold the rule of law. So in some cases, an excessive zeal in the pursuit of a client's interest has led solicitors to disregard these duties. But clear-cut cases are relatively rare. We have seen cases of solicitors taking unfair advantage of an opponent, misleading in court, or taking actions that lead to grossly disproportionate costs. And when this happens, public confidence in the legal system that underpins the rule of law is put at risk. But it's not always as clear-cut and as straightforward as that. So maintaining the high ethical standards that the public is entitled to expect is a critical task for us. This is a key purpose of our ongoing work to reform legal education and training. Our competence statement seeks to capture many of these key activities and set out quite clearly what is required of solicitors and how they can maintain standards. But there will always be complex situations where maintaining the correct balance between duties isn't simple, and all matters must be decided on the individual facts. So I would definitely encourage any litigator out there to have a read of the report, and you can always let us know what you think as well. It's always a two-way dialogue. We've had some good feedback that it's been helpful, particularly to junior litigators who are beginning to start that process of appearing in court and beginning to understand the litigation process and some of the finer issues around that.
Thanks, that's really helpful. I think one of the feedback that I've had about that paper is just that people find it helpful that we've recognised that there can often be complex changes in duties and things like that, and sort of complex decisions that have to be made, and it's good to have some support in that what is becoming an ever more sophisticated environment.
I think that's right, Laura. I've got one question here for you, which is that can you tell us a little bit more about the diversity toolkit that you mentioned in the lack of diverse and representative profession risk a bit earlier?
Yeah, I can. Basically, the diversity toolkit is something that we published towards the end of last year, and it's using the data that firms have actually provided to us about the diversity of their firms. So we require you to collect this information, but this is what we're feeding back to you to make a product out of it. And what it allows you to do is search for different diversity characteristics, different parts of the country or sizes of firm or type of firm, and then you can see charts that allows you to compare yourself with other groups of firms. So if you've got access to your own diversity data, you can then log on, see anonymised information from a particular region, a particular group of firms, just to get an idea on how you compare with other firms. And then sitting alongside that, we've got a comprehensive guide to why diversity is important to us, and also things that you can do to improve the diversity of your firm. So this is things like conducting reviews of your HR processes. So people have said that they found it useful, and that the sort of interactive format where you can generate different graphs is really helpful, because you can sort of cut and paste the charts into presentations and things like that. So feedback's been good, but we would advise you to take a look, because it's something a bit new for us, presenting data in this way. So we hope you find it helpful.
Thanks for that, Laura. It can be quite a challenging risk, can't it, to get your head around, and I think this year's Outlook really does try to put some meat on the bones regarding that risk, and there's some really useful case studies in there as well. Okay, so we've got a further question, which is about how do we monitor online-based or virtual law firms in regards to their compliance with legal risk? I guess we can both answer that. I think my view on that is that any firm will present a unique set of opportunities to grow and to deliver good services, and a unique set of risks that probably need to be managed. The example we always use is that we talk a lot about cybercrime, but actually the majority of things that come through the door are still breaches of information that involve paper. And, so we're certainly encouraging of innovation. We want firms to offer legal services in cost-effective and appropriate ways to their users, and it's often user-led. But of course, online or virtual law firms, as they could be called, will always pose a unique set of risks based on their characteristics. So we have done quite a lot of work on thinking about these kind of risks. We want to promote a diverse firm range, promote competition, but of course each firm still needs to comply with our general framework for practice. So we obviously have the compliance officer regime. We also have controls around who handles clients' money, and we do collect data from firms so we can understand what firms are doing out there in the market as well. And of course there are safeguards for consumers, so depending on the nature of their consumers, they can access certain kinds of redress through either the legal ombudsman or through ourselves, and of course we can monitor the conduct of firms to ensure that they are complying with the legislation and obviously our regulations. But I think the key point here is that we welcome those kind of innovations, and we will be as flexible as possible to ensure that our regulation isn't one size fits all, but it can actually be tailored to suit any kind of law firm that wants to be regulated by us. I don't know if you've got anything more to add on that, Laura.
Just an example, I suppose, because I've been involved with the money laundering visits that we've done and checking systems and controls there. And obviously some firms are operating models where each and every client may not be able to attend the office. And so they can provide a service where they can go to a solicitor that they've verified, that solicitor can verify the ID, and then that can provide the ID check. It's just as rigorous as if someone had come into the office themselves, but because they're a virtual firm, they've made sure they've got controls over the firm that's then checking the ID, so that it's still a good operating model and the controls are still there and they're still robust. And importantly, they're still able to demonstrate to us that they're robust, but they're just delivering services in a different way. So they've had to think carefully about how they still uphold that level of systems and controls. So I think for me, that was a really interesting thing that's come out of some of this money laundering work, is that it's not always about what you might traditionally think, but it's still as rigorous as ever.
Yeah. Thanks, Laura. Please do ask any further questions, because we have a couple more that have been sent in to us, but if you send one in, we'll definitely have an opportunity to answer it. So if there's anything niggling away or anything you want to ask us about anything to do with the presentation, then don't hesitate to get in touch. And we've been asked whether it's possible to have a transcript of our presentation as well as the full report. What I would say is we're more than happy to do that, of course. It's largely taken from the Risk Outlook and our online resource, and I would really impress upon you to go onto our website, click on Risk, have a look at our other priority risks. We've got it's like a grid where all the risks are set out. You can take the bits of information that you want. It's easy to cut, paste, to read. Each risk in the Outlook has one or two case studies, but actually on the online content there's 3 or 4 case studies. And I know for some of the risks, for example, the cybercrime risk, the risk regarding providing a good standard of service to vulnerable consumers, some of the case studies on there are really helpful and quite eye-opening to actually what firms can do to manage these risks. So I'd certainly encourage that. But yeah, there will be no problem at all with us producing the transcript of what we've discussed.
No, the webinar will also be available to download sort of shortly after today. So once we've turned around that recording, you'll actually be able to go onto the website and download this recording of us talking and answering your questions, and so you can use that as an internal resource or direct people towards it. So some people have found that's helpful, especially those that weren't able to attend today. So please do let colleagues and friends know that that facility is available. Now, George, I just wondered if you could pick up this question that we've had around innovation, because somebody has said that they know that we publish innovation research recently, but how that sort of fits in with the whole risk agenda, because obviously I mentioned about having to balance that innovation of firms, but also in the protections and everything like that. So I don't know if you want to say a little bit more, because I know that you were involved with the innovation projects.
Thank you. Yeah, this is really interesting. Actually, we launched it a couple of weeks ago. It was jointly commissioned between ourselves and the Legal Services Board on innovation in the legal services market, and a key part of that was actually understanding what does innovation look like in legal services and what actually is innovation. I think when we think of innovation, we think of technology first and foremost. We've lived through an age, Apple, Google, etc., where we're constantly receiving new consumer goods that could do things that we could never have imagined when we were younger. In legal services, I think it's a little bit different, and I think we found that 25% of providers have introduced a new service in the last 3 years. And one school of thought is, well, is that particularly good? Is that particularly strong? Well, actually, compared to other kind of service industries, it is. And then the second point will be, well, are they actual innovative services? But I guess it's about economies of scale. So, for example, if a solicitor is serving a community that currently doesn't have access to a good family lawyer, and then they launch a new family law service that's cost-effective and they promote it across that community, to the people using that service, that innovation has been of great benefit to them. It might not win any Innovation of the Year awards. It isn't an app. It isn't a new way of delivering legal services. But our understanding of innovation is that it's really about the absorptive capacity of the legal services market to change. And I think we found some really strong evidence that's beginning to happen. A couple of the key points from the research is that we found that firms that have access to a wider pool of talent and external funding, ABSs, for example, were more likely to have innovative practices than those that weren't. But actually, across the solicitor profession, compared to all the other regulated legal providers, solicitors did fare pretty well. But we know that there's more work to do, and I think the relationship between our regulation and innovation is probably the key thing I took away from the research project. It wasn't as simple as the case that less you regulate, the more you innovate. Actually, regulation has a really strong role in enabling innovation. So we can drive innovation, but actually, if we don't regulate well, we can stifle it.
Yeah.
So I think going forward the next 18 months, 2 years, it's going to be pretty integral to what we do, is making sure that when we reform our regulation, it's informed in a way that can encourage innovation, not stifle it.
Yeah.
But I would encourage anyone to have a look on the website for the report. It's fairly readable. It's a piece of academic research. It was commissioned by us, and the University of Warwick, the Enterprise Research Centre there, did the research. But actually, it's very readable, very digestible, and there's some really useful insights about how the legal services market is changing.
That's really helpful. Thank you.
Okay, so we have a question regarding not compromising independence. So I'll just read this out. Thank you for your question, Andrew. Not compromising independence is exemplified by you with reference to 3 other SOA principles and the misuse of the client's account to banking facility. Is it therefore fair to say that this risk is really about not behaving in conformity with an SOA principle? So that's a great question. I think we've got a challenge on independence that we are looking into, which is that what does it look like in the context of different kinds of firms? We understand that clients have a greater say. Clients can exercise certain controls over firms in respect of the services that they want to acquire from the firm. So it can be very challenging in that environment to sort of say there's a one-size-fits-all principle regarding independence. I would say that the idea of independence goes further than just conformity with our SOA principles. I think it goes pretty much to the heart of what being a solicitor is, which is that the idea of promoting and upholding the rule of law and ensuring that the proper administration of justice is delivered requires a level of independence. But what I would say on this is that we're soon to launch a more wide-ranging discussion on this very issue, really, or certainly incorporating this issue, which is that we're going to be launching something called a question of trust, and that will give practitioners and others a voice in actually forming where we go from here. And I think that independence is one of those sort of cornerstones that we do need to look at again and think, well, what does this actually mean in the modern context? So what I would say, Andrew, is that if you want to contribute to that work, you may already know about it, then please do. And there'll be more information through our Twitter account and our website, because we are really serious about consulting on professional standards and actually understanding what it actually means for different kinds of firms.
Yeah, no, I agree, George, and I think that one thing that we're aware of is that we need to be alert to the reality of professional practice and sort of understand the scenarios when professional principles are threatened and when independence is put at risk, because it's one thing explaining the concept, but it's another thing being aware of actual scenarios and the reality of practice, because, how firms interact with clients, what the leverage is on law firms to behave in certain ways. These are all things that are very complex and we're not going to get to the bottom of without understanding scenarios.
Thank you, Laura. And I hope that our answer around that also answered Susan's helpful question that was very much along the same lines. We have a question regarding why are some solicitors still falling for fraudulent emails? Are you investigating their systems and controls? It's a really challenging area, fraud in general. Who is to blame for fraud? You obviously put the blame at the fraudster's door, but of course solicitors need to have systems and controls in place to ensure that they're not subject to cybercrime and subject to fraudulent activity that they could have otherwise controlled. It is a difficult area, isn't it, Laura? Don't you have anything more to add on?
Yeah, I mean, I think it is difficult as well, because I went to a conference on sort of online fraud and things not long ago, and one of the things they were saying is actually things like, serious blame and sanction on the person who clicked on the email or whatever aren't necessarily always a solution, because encouraging people to report things and ask questions is really important. So, we have to be up there and think, well, actually, even though you might think, they're not going to fall for an email from a Nigerian prince or whatever, some cybercrime is very sophisticated and it's not always easy to detect. It may be that you feel that the person should have identified the email, but sometimes we look at emails and think, well, this was such a sophisticated phishing scam that we would never blame the individual that clicked on it. It's more about what systems does the firm have around educating people on these issues, and also just around what they do when something goes wrong. So one of the case studies that we've got on the web is actually about a firm that fell victim to a scam where somebody clicked on a link and it was sort of a ransomware application, which is where the firm's files are locked down and held to ransom if they don't pay a fee before a certain amount of time. But actually what the firm had done is protected themselves against this by having all the files thoroughly backed up. So if the data was lost, it didn't matter, because they actually had a backup of everything that was done regularly. And so we're not saying that excuses the fact that somebody clicked on a fraudulent email, but because of the sophistication of them, it's important that it's the systems, it's not just the individuals, and providing a space where people can say, I'm not sure if this is fraudulent, without worry that they will then be told off for that, I think is quite important.
Thank you, Laura. Let's see if there's any further questions.
Yeah, okay. We do actually have a question here about the anti-money laundering research, and I can answer that one. So the question is about, we mentioned a visit to firms, what information will be provided on that in the report? Because the report should come out later this year, and just to give you context to it, we went and visited hundreds of law firms to assess their systems and controls around anti-money laundering. This is something that the SRA has always place an emphasis on, but I think sometimes because money laundering investigations are quite complicated and quite very sensitive in terms of law enforcement, it can be difficult for us to put examples out there because there's still an ongoing investigation. But through this report, we hope that we can give firms ideas from good practice that other firms have used. So we'll be having sort of good practice examples on there, perhaps some examples where firms had poor practice and it improved, or some examples of where improvements required, just so that you can flesh out a little bit more what anti-money laundering practice today actually looks like. And I think for me, that's been one of the most things that the firms that we visited have found most useful, is that us actually saying, we're going to come and visit you and look at your controls, has made them think, oh, well, actually we probably do need to review this. And then we've got questions that we can ask the SRA when they come and visit to get an idea of what best practice is. So for me, it's been a really positive experience. And I think that when you see the findings, it's a good balanced mix of good practice, but also areas for improvement. So I hope that answers the question.
Thank you, Laura. So we have no more questions. So you do have another couple of moments if there's anything that's burning. Oh, we do have one in now. Thank you, Emma, for your question. You mentioned diversity monitoring data earlier. Do you know when firms need to submit their 2015 data?
All I can say about in terms of the 2015 data collection is just to keep checking the website, and we'll publish information as soon as we know. I think what we've been aware of is the fact that firms have found it difficult to collect data in the past, and we want to make that easier. So we're going to try and make it as user-friendly as we can be in the time that we have. So that's why the date's gone later this year. Okay. I don't really have much more information I can give you at this time, but I would suggest in the meantime having a look at the diversity toolkit can be helpful, because you can see the benefits of you having collected the data, and it may help get more buy-in from your firm in terms of submitting their information, because it is really helpful to be able to, at a glance, see different aspects of the diversity of the profession.
Thanks, Laura. It's probably worth saying, actually, that we will provide some like FAQs based on the questions that we've received today. And any that we haven't managed to answer, but I think we've pretty much got through everything. But if we get more information in, or perhaps we can answer the questions a bit more succinctly and better in some cases, I don't know, then that information will be in the FAQ. So, for example, if we know about the diversity collection date, we'll put it into there. But, of course, you should have received confirmation of that through our website and other communications prior to us doing that, hopefully. Okay.
Right, well, we've got a final question, so if anyone else has got any other questions, please send them in. But we've got a question to answer, which is just around taking the risks as a whole, rather than about a specific risk, and just saying the risks are very similar to what were provided last year, but last year you had priority risks and other risks, whereas this year they all seem to be on the same level. Is that because the priority of risk has changed, or for another reason? So, George, I don't know if you want to pick that up.
Thank you, Laura. I think it was always difficult to justify a kind of scientific distinction once you'd identified these issues as issues. So I know in the first years of the iteration of the risk outlook, we talked about key risks and then other priorities. I think that can sometimes send out mixed signals. I think it's much easier, and this is a personal view, just to tell the profession what are the 8 things that the SRA care about. I don't know how the profession feels, but I find that having these 8 things out there, the idea of these 8 key priorities, it really helps inform discussions at events and when we meet each other as well. So when I talk to practitioners, you can talk fairly openly and candidly about each of these different kinds of risks. So we'll have a chat about cybercrime, we might have a chat about diversity, a chat about regulatory reform in respect of client protection. So I think the main reason for that isn't that we've necessarily identified changes in the risk profiles of the other priority risks, if you like, from previous iterations, but actually beginning to understand that we do care about all of these 8 things, and you can't scientifically measure these risks. So, for example, with easily identifiable risks, risks that consumers and third parties can identify, is happening within a firm, we receive a report and we can collect that data and we can understand how many reports. So you noticed earlier I referred to the number of reports we've received about misuse of client money. However, that's much more difficult. You can't really apply that when considering something like lack of independence or improper and abusive litigation. Certainly not with the risk around diversity. So we've had to really think about our evidence base and think about, well, not just looking at what comes through the door and what we see, but actually as a regulator, what should our priorities be? What would consumers expect our priorities to be?
Yeah.
And that has driven a lot of this year's work, I think. So we've been quite open in saying, do you know what? We care about poor standards of service of vulnerable consumers. Yeah. Yes, there's redress, there's legal ombudsman, but as a regulator, it's something that we care about as well. And that's quite an important message, I think, from this year's outlook, that the idea of providing good standards of service isn't something that the SRA has forgotten about.
Yeah, no, I agree. And I think it's also worth saying that in terms of the evidence that we use to write the risk outlook, we consulted with sort of members of the profession, whether that was through events or, as speaking to people on an ad hoc basis at conferences, etc. And we like to think that although these are risks to our regulatory purpose, they are the sort of two sides of the same coin with the type of risk that firms will be thinking about in terms of effectively managing their business. And us saying X is a priority over Y is inevitably not going to apply to each individual person. And so I think it is helpful just to say that, we want firms to look at this information, use it as the jumping off point to say, well, which one of these matters most to my business?
Yeah.
And then they can then take sort of some of the online content we've got, etc., to try and help them manage that.
Thanks, Laura. We do have another question. Thank you, Barry, for your question. You've asked us a couple of things today, and we appreciate it. This is one for Laura. So Barry's a sole practitioner. He doesn't employ anybody else. Can you let him know why he has to provide diversity information?
Oh, okay. Well, we do have the policy of asking firms to collect diversity information, and that includes sole practitioners. But one of the reasons why is because we are aware that there are certain groups, such as Black and Asian and minority ethnic solicitors, who are underrepresented in the larger firms. So this may be a personal choice. I mean, lots of people choose to be a sole practitioner because that's what they want to do. It serves their lifestyle, it serves their talents. However, there is evidence that some Black and minority ethnic solicitors have reported facing barriers to accessing jobs at larger firms. So if we can understand the diversity of small firms and large firms, sole practitioners, in-house, etc., we can understand more about what these differences are and look at whether they change over time. So it's really important that I stress that it's not about saying that there's a problem in any particular firm.
Right.
We're not saying, you need to sack a man and hire a woman or anything like that. It's simply that we want to get an idea of what's going on at the whole profession, allow different members of the profession to understand how they fit into that picture, and then we can measure progress over time. So I hope that's answered your question. The diversity toolkit does have what I think is a really good explanation as to why we care about these things and why we collect diversity data. So if you wanted a little bit more detail, I would suggest if you go onto our website and search diversity toolkit, you can access that paper.
Thank you, Laura. And thank you, everybody, for joining in with today's webinar. Another couple of moments in case there's another question that anybody's burning to ask, and then we'll move to begin to conclude today's session.
Yeah.
Well, thank you for your questions. They were all really, really useful and helpful. This webinar will be available to download from our website pretty soon. I think Laura's got some closing comments to say with a bit of housekeeping, so over to Laura.
Okay, so we've now reached the end of today's webinar, so thank you from both myself and George for attending, and we hope you've enjoyed it. If you'd like details of future webinars or events, please visit www.sra.org.uk/events. And to read the Risk Outlook and access our extended web content, please visit www.sra.org.uk/risk. We're really interested in your feedback on this webinar, and we'll use it to improve future presentations. If you'd like to give any feedback, please click through to the feedback survey by clicking on Document/Links and then choose Survey Link. You can also use this button to download today's slides. Oh, okay, sorry, I've just been informed that the format's slightly different. So to complete a short survey, click Resources and then choose Exit Survey. So Resources is also where you can download the slides from today. So if you can't see these options, just switch out full screen mode and they should be available. So I guess all that's left to say is just thank you for attending today. We hope you found it useful, and please access the rest of the content if you would like any more information.
Thank you very much.